I'm looking at not one, not two, but three indictments. In 25 CR 1243, you're charged with the third degree felony of operating another vehicle while intoxicated. A third degree felony because you have at least two prior DWI convictions. Actually, they're alleging three. And then you're looking at up to 10 years in prison if found guilty. However, it doesn't end there. You are indicted. It's alleged that you have one, two, three prior final convictions, and you were a habitual felon up two convictions ago. In 1995, you were looking at habitual felon status in 99, rather. So this third degree felony is enhanced. If this is true, you're looking at no less than 25 to life imprisonment, 25 years to life imprisonment on that. 26164 is a state jail felony would be the possession.
Yeah, would probably be a 2 to 1.
Cocaine, this case?
Yes, sir.
Yeah, it's a state jail felony with two prior convictions, but they're not sequenced within the same day. So I think it's just a third degree.
Seems like if there's sequence to the DWI,
It's not the way it was arranged.
I sure did. I'm not going to complain about that.
We can fix it for you, right?
I think the way the state would probably end up alleging would be the
You know what? It is in sequence. Yeah, there's a 97 conviction of robbery, then two 2020 convictions, which are alleged to have been committed and sentenced after the 97 conviction was final. So that state jail felony is enhanced up to second degree felony. And then finally, there's another state jail felony of illegal possession of cocaine in 26 CR 165, and it's a state jail felony with the same three enhancements. And that was on a different date. And so it's a state jail felony punished as though it were second degree felony. So this isn't good. You're looking at on all of this 25, 20, and 20, 65 years.
That's a minimum of 25 on one.
25, 65 years in prison on all of this.
life.
And you are born in 77, 23, 26, 53. That pretty much outlives you. But these are a product of your choices. All right, what are we going to do today?
I said it for trying.
Is that what you want to do? Okay. Set for trial. Also sit over there. You're going to get tested. Good luck. Your history has not been good. I would be in Las Vegas betting on this one. Oh, yeah, it's possible.
And then with
Next, who's up?
Mr. Hicks.
Yes, Mr. Hicks.
Because
Where's he? What do we need him out?
That's the case Mr. Florence briefed for the court on the mental health expert for the murder trial. The court may be familiar with that. Well, the court, you recall that.
I do. We need Kalen Hicks. Does he need to be out?
It's up to the court.
It's up to you.
That's fine. You can stay back.
All right. Don't worry about it. All right. This is the summarized. Here's the motion.
Your Honor, basically what we were asking for, I know I'm retained in this case.
And this is, I'm sorry, 23 CR 43, the state of Texas versus Kalen Hicks, charged with a first degree felony
Just an achy motion.
of murder.
Achy motion. Candy? Candy? Well, if it is, I don't need to be involved in it, but if it
No,
isn't, then
it's one. Well,
It's one that you're trying to get an expert to look at him as, so you could decide what to do with it and not want me to see it,
Well,
or you want me to see
You
it?
can see it. I don't have anything to hide from it. I mean, because you may get your own kind of evidence.
Just trying to figure out what your strategy is. Huh? I'm forming it as we speak. Gonna come alive.
Just let me know when you're ready to get on the record.
All I need is one witness to say one word and I'm off.
Sometimes it's too easy.
Yeah, that's what it was. You've had those where you, and you go in there and all of a sudden somebody says something, you go, whoop, they just came.
We don't play it. Carry on.
You're right.
You know, it's funny, it's what they do. Like I'm able to see what you. Oh, wow.
Hey, you got to go out there. Well, he's already evaluated that. You got the contacts and exhibits in the project. But to give an opinion of whether he was able to, basically his cognitive functioning, to knowingly and voluntarily
Waive his rights.
And then the question of voluntariness to the jury isn't a question for the
The
jury.
thing is that he lied enough to where I can say, yeah, he knew what he was doing.
That's up to you.
And then he finally told the truth, but yeah, I know, but.
And then in punishment for mitigation.
All right, here are your,
That's where I'm going. But
here are the options. You're asking for
Dr. Holmes will be appointed as a defense
Whoever
expert.
it is.
This is the one I'd like because of this
I know,
project.
yeah, but you have several options, according to the, case law, and this is the Briggs decision,
Yes.
which is, a leading decision on, acquiring assistance of expert witness or other witnesses in your preparation of your defense. When it becomes clear that the defendant cannot come up with the fees or additional money from medical experts, a reasonably competent attorney has options. One, subpoena all the doctors.
Yeah, that would include me, right? The reason comment, let's be clear for the rest.
Should we not?
Just what.
It sounded like you were objecting to being included in that group.
Or to take judicial notice and obligation to comment.
All right. Are you pretty comfortable with moving forward on this without being an exception to the rule?
Establish that.
Subpoena all the doctors who had treated the defendant during 2 months, during the time period and testified.
Dr. Holmes.
Okay, and here's the deal, when they're subpoenaed, they can't say, can't get paid. Now, they can get paid, I guess, a reasonable amount of money, but they don't have a choice if they're subpoenaed.
Fact, and I'm having difficulty getting him.
Well, then you mandate, you can get if he has to be
Yes, sir.
forced into
Rid of
it.
attachments.
That writ of attachment is why that was invented by the good Lord and the legislature.
He evaluated Mr. Hicks back in 2018, and that evaluation is attached to the exhibit.
If counsel is convinced that the defendant cannot pay for experts to assist him in preparation or to provide expert testimony, he can withdraw from the case explaining that the applicant is now indigent, prove indigency, and request appointment of new counsel. Are you being paid as an indigent attorney or are you
No, I
retained?
was retained. I
All
have.
right, that's the second option. And three, remain as counsel with the payment of a reduced fee,
That's a reduced fee.
but request investigative and expert witness fees from the trial court for a now indigent client pursuant to the Aki versus
I
Oklahoma.
could put on his mother.
You got three options. What do you want to do, right?
I could put on evidence as far as his financial status. Is that Ms. Hicks or Michaela's, his mother?
Right. Well, just put it in the record. You're an officer of the.
I would say it's a reduced fee, and I could put evidence of what the fee is on the record, and just, and I know that everybody here wants Mr. Hicks to have a fair trial, and I think that in order to effectuate that, this mental health status needs to be something that's addressed during the trial, whether it's a
All right.
winning strategy or not, I can't say, but it's something.
Put into a small writing and then I'll seal it because, and we'll put it if it's ever needs to be reviewed, but I just don't want the public looking at your finances. You know what
I
I
don't
mean?
have any problem calling others. He can tell you what you pay. You want to come up, man?
You're
That's just.
an officer of the court, Mr. Kimball. What you want is good
Just, I think it's less than 2,000 that I've been paying.
Okay, so that is a third option. Remain as counsel with payment at a reduced fee and request, but you're requesting investigatory and expert fees from the trial court for a now indigent client. And the defendant just needs to fill out an indigent form
Okay,
and get him signed and then request that in a real succinct motion and I'll grant it.
okay.
So
So
we can
would you
look at-
grant Dr. Hamza or is it just?
Well, it doesn't say you get Dr. DeBakey or, it just says
I just,
competent.
I just say that because he previously has stability guarantee with the defendant.
That's fine, as long as he's not going to be extraordinary in his fees,
So I would have to get, I'm trying to figure out what the fee, when I get the fee, a quote from him and then get it approved by the court. We'll get it out.
Yes, I just get it to me and then I'll sign off if I deem it to be fair and reasonable, which I'm sure will be,
I
right?
guess we got to do.
I understand. I think this case says you can subpoena and also take care of it financially. Mr. Swafford? Swafford?
Mr. Swafford, he's the best leader.
All right, bring him out.
It's gotta be, that's what you gotta do.
Yes, sir.
All right, there's the.
Oh, you have Swafford,
Langston does.
Langston?
But you've already raised the bond, that was just bond of 30,000 plus the chief has device. And then you.
I just need to bring him out and put something on the record here quickly on Swafford. He flunked.
Mr.
What was the betting line in Las Vegas on that?
Yeah.
Las Vegas wouldn't touch it.
Mr. Parker,
Mr. Swafford.
Not yours, not yours, no, not yours, no. Yours hadn't tested yet.
No,
I
he
think you
he
did
had
right
pretty
now.
much admitted it.
I'm sorry.
He admitted it.
Yeah.
Mr. Swafford? As you know, your bond has been revoked here and also we've just finished the drug test. You've tested positive for tetrahydrocannabinol, marijuana. And again, you're coming to court with illegal drugs in your system and that is a condition of bond one, do not commit an offense and illegal usage of marijuana is enough to satisfy that bond condition as a violation in your case by preponderance of the evidence or greater. And for that other reason, your bond is revoked. Also, I think I ordered a drug patch.
Ordered a GPS device.
I'm ordering now a drug patch as well as a condition of your bond as well, sir. And we will get that information over to your attorney. And so he will know, okay? Thank you. That is all. All right. I think that's it, isn't it?
Judge, we just have one in the back being drug tested.
That's fine,
Mr. Parker.
It's just on the other side. I'll have to get around.
I never, I was reading. You were reading on time? Well, Dustin's following red.
Yeah.
Because, marijuana park in Louisiana.
Everybody's on the drug test so far, so we're gonna see if it can continue. Who is it we're testing now?
Parker. It's gonna be.
Where is,
Hopefully not sending your price list over.
Well, this guy, yeah, I think it's so, but he's like.
You said okay.
No, he should have.
I hear here's Raheem Prepost.
Oh.
Thank you.
I'll be a call.
Let's see Parker's fine for just a second. Oh, I am. These three.
Oh, here.
Trial.
Yeah, here. I have it.
Oh, yeah. Yeah, this one's got it. The odds are long on this one.
Or the day first felony for sending. Is on a murder case that you have for the.
How we doing on, everybody ready? When we shrug? Oh, you got more
I
diary.
called her this morning and she said, yeah, that's.
To do that.
She might let us know if she got some trouble.
To say something, I'm not, I never know what I'm saying.
Said,
Yeah,
yeah.
next week, she said, yes.
If only that were
We're
true.
beginning with once upon a time, and you can just pretty much, be creative after
All three
that.
of y'all will appreciate this. We were at a dinner party the other night. And I said to the judge, I'm real concerned that you won't ever grant my motion to change the facts. And he goes, just immediately just comes right out with, he goes, well, if you wouldn't start them with once upon a time, then I would probably grant them. And I thought that was great.
You put yourself in very.
I really did.
Good for him. Very good for him. All right. Anything else? So what are we doing with it?
That needs to be reset.
Okay, we're, we're, okay.
Parker. Yeah. Speak. Yeah. Place them.
Did you hear?
Sure.
You knew that. No, you always know, the person always know better than I do, that's, but we still test. And at all times, hopefully that inspires you to keep making the right choices. If we can help you do that.
Delay it as long as we can.
No, it's not gonna happen that way. That's not the right thing. I know you
It's
find it
years, it'll be years.
comical, but no, that's,
I'm anticipating a nuclear exchange occurring before this case.
there's, the problem is the criminal history. Well, what have you done to try to resolve it, to maybe do something other than put him in prison for the rest of his life?
I'm sure the states.
Well, you don't know that.
He's got three.
I know, we can try one, then the next one, the next one. What did we say, 50 years?
How much later was your?
There's, you know,
All I know is tonight he's going home.
no, there's 25.
See what happens.
Yeah, so he's looking at 25 to life and then 2 20s. So that's 65 years.
We
All right,
are,
there ought to be, and you hadn't thought about something that might be done other than put him in his option,
split it off.
facing a jury and.
Just split it off.
Well, here's what we do is we try it and it's the 25 to life is what's gonna be tried first. And then we'll go to the next one afterwards.
Story, which ever heard the story of him singing?
That's,
Mr. Rodriguez, and used to,
well,
him singing hymns.
what else? Anything else? All right, let's go to trial. Here we go.
Sorry.
Get ready for trial. Thank you.